Welcome to Big Blend Radio's California Employment Law Podcast featuring San Diego attorney Ward Heinrichs. So welcome everyone. Today we're going to talk about DEI. Yes, that is a favorite word, right? Apparently it has changed. DEI under Title VII, and this is all to do with the Equal Employment Opportunity Commission and some changes that just happened at the end of June this year. So Ward, didn't we talk about this the end of last year? We were talking about DEI. I can't keep up on when, but
Yeah.
it was
y- w-
starting. There was the rumors of change.
Yes, we did one last year. I think it was last year about this time.
Yeah.
And we were talking about Trump's signing executive orders and maybe slightly a Supreme Court case that had come down. And since then, we've had the EEOC go in that same direction, saying, yeah, the way we've been doing Title VII and discrimination isn't really fair.
Ooh, okay.
Mhm.
Well, I'm not going there because, I'm not a lawyer.
Well, I'm
But
just telling you what the EEOC says.
yeah, so that's what they're saying. So this is important for business owners to know about, right? So the
Yes,
guidance you
definitely.
said, and everyone, Ward's got an article linked in the episode notes there. But the first thing you say is change is the guidance is withdrawn. So do they just go in and say, that's it, this part's being taken out? Like, what do you mean about the guidance being withdrawn?
Yeah, so the EEOC has guidance that's official. I call it official guidance. This is how we're going to approach these cases, and so it's posted so that the business community will know what to expect. And so the guidance had been, well, if you are of a majority ethnic group or majority sex or something like that, then you aren't going to. We're going to focus on promoting minorities. I think that's probably the easiest way to say it. And that was the old affirmative action DEI stuff that we'd seen for years and years and years. And now the EEOC says, no, that's not right, because what that does is discriminates against the majority. And the statute, Title VII, and the Constitution says you can't discriminate, period. Doesn't matter. And so if you do things to promote a minority that aren't based in skill, knowledge, etc., then that is discriminatory.
Oh, so you're damned if you do, damned if you don't. So you better just sit there and do the right thing and hire
It's a
according.
big change. It's a huge change. And, with the new president, and, in 2028, this whole could change back. I mean, who knows? It's just a real political fight right now. And the huge change also is, well, we're not going to promote people in minority groups just because they're a minority. I mean, I think that's the simplest way to say it, because that actually discriminates against other groups, even the majority group.
So really, it goes down to your work merit.
Yes,
know.
and that's the advice that I give. I say, when you try to promote someone, focus on merit and skill. Don't focus on ethnic group, sex, or anything else. If you promote the people who look like the best. Now, of course, that can be a gray area, but as a general rule, that's what you really should do. And that's what I advise.
But that's the thing too. There are also, if there's a thing that is also trickled down in regards to this person was hired as a token so and so. Do you know what I'm talking about in the workplace culture?
Yeah.
So it becomes like you were only hired. So it creates more discrimination at times with that, within the employees. If someone was hired and they think they were only hired to meet a certain quota of how the makeup of hiring, and and maybe they weren't, but do you know what I mean?
Oh, it's possible. And you saw that all the time. So often companies would hire an ethnic woman because it filled
Oh,
two categories. And so now the EEOC is saying, no, don't. If you do it for that reason, that violates Title VII. That's what they're saying now. So, but if you can show that you promoted this person then great.
Okay. So this has to do when you hire and when you promote and when you fire as well, because if you
Yes,
fire someone
always.
over any of those.
Yeah, those. So if you get denied because of your race or sex or whatever, at a job interview, if you're not hired because of that, that's
Mm.
discrimination,
No
and you
matter
can file
what.
a lawsuit for it. Yeah, no matter what. So that's what we call an adverse employment action. So anytime there's an adverse employment action because of one of these protected categories, ethnicity, race, et cetera, and if you do that, then that's a violation. You're
Okay.
not allowed to do that in any situation. So again,
What about
if you
age,
fire
though?
them because of that, yeah, you're right. That's an adverse employment action.
Age. What about age?
Age is a little trickier because Title VII doesn't talk about age.
Oh,
And
just
these
skips over that, does it? Just kidding.
Title VII, just about religion,
Oh,
sex,
okay.
ethnicity, race, things like that. So that's the only thing that it protected. There's a different federal law that protects ageism. It's called ageism. But I think you're going to see, and there hasn't been official pronouncement that I know from the EEOC, but I think you're still going to see that if you're promoting just because of age, or if you're hiring just because of age, that would be a violation.
Okay. And so everything we're talking about right now is federal.
Yes, but that doesn't mean it doesn't have effect on states who have laws that allow affirmative action or quotas.
Okay. So now where's California in all of this?
California is still on the affirmative action side. There's lots of laws that we've even talked about that have recently been passed. For instance, what's the makeup of your board of directors? Remember, we were talking about that. We need more women, we need more minorities, and there's a base number that you have to have. Remember, we were talking about all that?
Yeah.
So California is still in that camp, but that doesn't mean that the EEOC, if you're a company and you're in California and you go, all right, I'm going to promote this lady because she's Asian and is a woman, then EEOC can come in and say, that violates Title VII.
Okay.
You can't do that.
So federal trumps the states.
Not always.
Well, come on, Ward.
Yeah.
There's never just a clean cut thing, is there?
Yeah, well, there is the supremacy clause in the Constitution, and it says federal law trumps state law. Bottom line, that's what it really says. And there are times in federal statutes where they say, hey, if you protect so-and-so more, that's good with us. We're good with that. And so a real typical situation is wage and hour law. If you have a higher minimum wage, you get to enforce that. California, which has a much higher minimum wage than the federal. I think federal's still at $7.25 an hour.
Oh, wow.
Yeah. And so most state laws are beyond that. So most state laws
Yeah.
are enforced. Wyoming, oddly enough, at least they used to, and I mean, it was true like a couple of years ago, they use the federal standard. Anyway, so there are situations where state law, I wouldn't say trumps, but is allowed to be more protective
Okay.
based on what the federal law says about doing that.
It's always so confusing, but and it's not just employment law, right? That has this federal versus state. I mean, and then like where you are in San Diego goes, well, we're going to do this even different on minimum wage compared to the state level, So I think business owners, you really have to watch all this stuff and get it straight for your state. And,
It'd be confusing. I work with it all the time, so it's not confusing to me. I get it. But if you're just trying to make decisions, and of course, entrepreneurs especially, they've got a million things on their plate. Do they really understand the supremacy clause? Do they really understand that there's laws that aren't trumped by the supremacy laws based on how the law was written? Probably not. So, you need some help sometimes.
All right. So advice for someone opening a business right now and looking at who they want to hire for what is you're going more on what? Don't look at the makeup of gender or anything like that. But then, how did Hooters get away with it? Because you look at them, they have mostly women. So now how did they handle this?
Boy, that's a good question. There was a Hooters case. I'm not really recalling what it said, but
That goes
so
with the
why
makeup
does
of their
Hooters
company.
get the
Yeah.
hire busty women? Now, I remember, yeah. There was a non-busty woman who said, wait a second, I should be able to get this job. And I don't remember what how it ended up, but I'm pretty sure it ended up, yeah, no, she's qualified. She can do this job. But don't quote me on that. I'm sorry. I'm kind of riffing here.
Yeah.
Warning,
It is hump day.
but I've never heard of anything about a man going, hey, I want to be hired at Hooters. And that would
Oh,
be
they
interesting.
probably do.
That would be very interesting. Yeah, I want to be a waiter, waitress, wait
See, but
person.
there's a lot of things that are kind of gender specific, you know? If you're gonna be in the
Yeah,
Chippendales, you're gonna be male.
yeah. And you know what I'm going to say about that is, there's probably some case that talks about this in a more general way, and I just don't know. But I don't think the people that are hiring those entertainers are mad that a woman's not with them.
Yeah.
And I don't think there's a woman that says, "Oh yeah, I want to do that and be with these guys on stage and do my own thing." Plus, if you really want that, I'm sure you can pay the money to have it.
I just think it's a interesting makeup on that because there's just certain things that are
No, it
divided
is
up.
interesting. I mean, and look at
And that's just
construction.
the first thing that came to my head of
Well,
that. That
construction.
yeah,
I you rarely see a woman on a construction site.
they're there, they
Is
own
that
their own
discrimination?
companies.
I mean,
No.
could a woman bring a case based on construction sites? They used to be able
Mhm.
to. I was going to say, I don't know how often it's happened. I'm sure it's happened. But now, if you're saying, "Hey, look, what I really need is someone who's strong, and these 20 guys are stronger than this one woman," to do this stuff, I think that's related to the job. It's needed, and so you can say, I did that for meritorious reasons.
Mm. The interesting time because it's even interesting what's happening in our military. Same kind of thing. It is kind of we don't have to go there, but I'm just saying,
Yeah.
it is just an interesting time about all of this and everyone's arguing about it, but as a business owner, you need to go with what the law says no matter what, right? Unless you want to
Well,
somehow
no, I
change the
think you're
law.
taking risks. I think you're taking risks that the EEOC, if you don't, there's nothing wrong with hiring for merit.
Yep.
There's nothing that outlaws that. Now, under the old EEOC guidelines, if there was an impact that was discriminatory, so meaning you didn't mean to do this, but you happen to have all white guys, or 90% white guys who were under 40 doing this, then that disparate impact, that's what they call it, disparate impact, could lead to a case under the old EEOC rubric.
Okay.
Because even though you didn't mean to do anything bad, it just had a bad effect against these non-minority people. That's the EEOC says that's gone.
Okay, that makes it very clear. Yeah. And so, but now it's like it's open for everyone, only go by merit, and that's that. And but however, if there is any kind of discrimination, you're going to get in trouble, which should happen.
And what they're talking about is what I would call overt discrimination or intentional discrimination, where you
Okay.
where you can say, "Hey, look, they really are picking on me, and here's why." Yeah.
Yeah.
So EEOC is saying that's okay. But they're also saying, well, in that case, that means reverse discrimination is okay too. And I could get into the weeds on this. There's a case, I'll do it quickly and simply, hopefully. There's a case, Ames v. Ohio, that said this white lady who wanted this job for promotion, wanted to get promoted, does have a case, even though she's in the majority, because what happened was a lesbian got the promotion instead, and then a gay man or a bisexual man, I think it was, replaced her in her job, and they demoted her. And they said, even though she's in the majority, she has a case. And the reason why that's important is there were a bunch of federal districts, circuits, the appellate courts, that had said, well, you can't use just the old test. I'm not going to get into the old tests that we use, simple test, show that there is some discrimination and we'll let you go forward. Then the employer has to show that there's a legitimate reason for doing what we did. It's not
Hmm.
discriminatory. And then the burden goes back to the plaintiff, the employee, saying, well, it's a pretext. That's the word they use. A pretext, not they didn't do it for that reason. They're saying they did, but they didn't. But some of these courts said, well, beyond that, if you're in the majority, you got to show that this is the unusual type of employer who does discriminate against the majority. So it raised the burden for that kind of case, for that kind of situation. And the Supreme Court said, no, you can't do that.
Hmm.
The districts, the circuits that are using that test are wrong. They can no longer do that. And that opens it up again for reverse discrimination. The EEOC said, we buy into
Wow.
that. We think that is the law. So I hope
Whew.
I didn't lose you on that one.
Took us
It,
on a journey, but that's
it's
okay.
a journey,
Well, it is
but
because this is not it is not cut and dry. But it kind of feels like it is more cut and dry now.
Well, it is. And the Supreme Court has changed, says, no, this
Mhm.
stuff, you can discriminate against the majority. You don't have a heightened standard of proof to show that they were discriminated against, because that's really what was
Yeah.
happening. And then the EEOC says, yeah, that's right. And we just want people promoted for merit. That's it.
So that's it. That's what everyone just needs to keep in their minds at this
I
point.
really think you need to err on that side, and even under a California law, which may, like I was saying, how many board members have to be this, la da da da, have some laws that would promote DEI. I think if you can still show, well, I did this based on merit, you're gonna be okay under California law too.
Okay, so changes. Merit is at the top of the list.
Yes. Yep.
Okay. So, and then you said also look in your article, you brought up, okay, so we talk about the shift into federal and all of that, but you did some recommendations for employers that I thought is important to bring up today. You said avoid quotas, targets, and preferences, using quotas and demographic targets that could be proxies for preferential treatment. Woof.
Yeah.
Give an example, please.
Well, it's really what we've been talking about. If you say, I want to promote this woman because
Okay.
she's Asian, that's
Those
demographic.
quotas.
That's a
Okay.
quota. Yeah.
Okay. All right. I got it. I got it. So don't have any of that written down anywhere either. Would this be a time for people to clean up their anything
Wait,
written?
well, yeah, no, you need to change policies if that's the type of policy you have. Or I'd recommend that probably. And there may be a situation where I might, depending on what's going on. But anyway, yeah. And what you need to show is you're doing this because of merit. So that part certainly should be written.
That part be in there. Okay. And then the other thing we talked about not too long ago, I think it was last year too, is AI and the hiring process. Oh, it
Oh,
was
yeah.
it was this year. And you talked about be really careful about setting up your AI correctly through,
Yeah.
looking at resumes. So this kind of really goes together with that whole thing about be careful
Well,
on how.
there's a relationship. Yeah, there's a relationship because AI is based on human thought. And so then it learns from more human thought. Again, it's a robot. It's just absorbing material, it absorbs it very fast and processes it quickly, but it's still a fancy robot. And if you have unwittingly put in discriminatory bases, then the answer that AI gives you could be based on discrimination. Now, of course, this is what we're talking about now has changed that a little bit because, well, maybe a lot, because if your AI was based on DEI, which was okay a year ago, now you may face the problem of reverse discrimination based on your AI decisions that AI has made. So you may have to
Wow.
reprogram AI, put it that way.
And there are people for that.
Well, sure.
There are
Yeah.
specialists in that, and I think it's important. That's a whole new career field is setting up your AI correctly and
Oh,
having
yeah.
to do
People
it.
are talking about that a lot. I agree. Yep, yep, yep. And how to roll
And
it out. And yeah.
yeah, so is that happening in regards to like lawyers being involved in certain things with AI, going in and checking what you are putting in there as like the foundation, especially for, hey, we're looking for these kind of people now. Do they ever give you like this is what we're doing? I mean, I kind of if on the hiring process and those kinds of human relationships, I think I would want legal counsel or at least HR that has some legal backup to.
And I think you got to run through the AI decision making process, different scenarios, and see what it comes up with. And
Yeah.
I think you got to check that. And if lawyers, sure, if the lawyers are making hiring decisions, they need to be aware of what we've just been talking about. And if they're using AI to do that, then maybe they need to reprogram their AI and how it's thinking about these things. But most, I think, law firms are really, when we're talking about AI, are really concerned about, well, does AI hallucinate? If I just let AI write this brief, this is big in the legal community, then can I just hand it to the judge? And the answer is no. You got to check what it's saying before you hand it in and make sure there aren't a lot of mistakes in there. And there have been, and people have been fined. And I don't think anyone's been disbarred, but, highly sanctioned for just handing in an AI brief.
Well,
So that's been
but I
more
think
important
for
with law.
with law and the legal content, but then also for you as an attorney helping a business set up their AI to make sure that they're not inputting like the wrong things?
Well, and I know an ex-attorney who is doing that a lot. Now, could I get called in on that? Sure. I could say, "Hey, look," and I would do just what you're saying, and I haven't been. So I just want to be upfront about that. No one's ever said, "Hey, Ward, can you help us reprogram our AI?" No one's asked me that. But if I were, I could say, "I think I can." And what we're gonna have to do is put in some information, a proxy hiring situation, and see how it works, see what the answer
Yeah.
is, see how the process unfolds. So yeah, no, I would do something like that.
Yeah, I think it's going to get to that level. I really think a
Well,
lot of
I think it already is. Like I said, that
Mhm.
ex-attorney, and I think she's still licensed. She just doesn't practice law anymore, and she's doing that a lot. She's promoting it a lot.
Wow, we have really changed in the last 5 years. Just
But I think in the last
yeah,
2 years,
yeah, really. I mean, yeah, I mean, we've got a new president, right? Kind of
uh,
new. But I mean, and so a lot of legal changes with that, but then just the whole AI world.
the whole
And
AI thing. To me, 3 years ago, yeah, we were talking about AI. We're saying, remember we did that
yeah,
show, The Artists,
yeah,
and and that was interesting and fun. But we really weren't into the nitty-gritty that we are now, and
yeah.
the cottage industries that have evolved since then trying to say, "Hey, AI, it can be dangerous too. We really gotta look at this thing and
Well, I
make
mean,
sure we use it properly."
I think it's really comes down to with everything with this. What are we inputting and receiving? And we have to, you have to check AI just like you would an employee's work,
Yep.
right?
Absolutely. Absolutely, that is so true.
Everything, check it. So,
Yeah.
woo. All right. So everybody, big changes, and we know more are coming, right? Because we're heading towards the fall, and don't they do more change in California around fall, October, new
Then
laws
we
or anything?
see the yeah, when the governor starts signing laws is usually late September, early October, and we
Mm.
start seeing the laws that we're gonna be facing. And that's why at the end of the year, we always have our little, next year's employment law changes,
Yeah.
and I'm sure there will be some.
I have a funny feeling you're going to have a big list for next year.
Okay.
Yeah.
You
Yeah.
might be right. You might be right.
Everyone, best employment attorney, san diego.com is where you can find Ward. You can listen to his podcast from his website, read articles, read his magazine, and we will see you next month. I wonder what we're going to get into. We could meet at Hooters. I'm just kidding.
Only if I have a job there, then we
Okay,
can
there.
have
Oh, all
lunch.
right.
You're welcome.
Thank you for listening to Big Blend Radio's California Employment Law Podcast with San Diego attorney Ward Heinrichs. Keep up with Ward at bestemploymentattorneysandiego.com or follow him on LinkedIn, Facebook, and Twitter. You can also subscribe to Big Blend Radio at bigblendradio.com.